is faced by the local government. So basically it is a restrictive thing and says that it's a bar, not a enabling provision for legislation. Then what is the meaning of subject to law? My humble submission is that subject to law does not mean, it implies the implementation rather than grant of power, number one. It doesn't imply, it implies implementation rather than grant of power. If rule-making power is made subject to legislation, sir, then the rule-making power of Supreme Court will become functus officio. Constitutional grant of rule-making power is construed as a continuing power, sir. So there cannot be any limitations on that, or constitutional power given that. It is not an enabling provision. Subject cannot mean subject to legislation, sir. A subject law is interpreted as Supreme Court's rule-making power are subject to then, that would be a grave violation of independence and separation of powers doctrine, sir. Subject law means substantive law. Subject to law means substantive law as distinguished from pleading and practice. Substantive law includes much more than legislation. It includes common law. Subject to law means power as to practice must not invade the field of substantive law. So there has to be something existing. It cannot invade the field of substantive law. But it does not give them the power to legislate, sir. And sir, with your lordship's kind permission, I have prepared
what you're saying is that the parliament cannot make rules nor legislate regarding the rules. And all the parliament can do is subsequent legislation नहीं हो सकती. ये जो existing law था उसके दायरे कार में रहते हुए और कानून
आप rules नहीं बना सकते.
Constitution के दायरे कार में रहते हुए power in any event vests in the Supreme Court.
Supreme Court exclusively, sir, because the word used is not just rule making; it is regulate. That we can by rule regulate the practice.
I'll read the provision.
Yes, my lord.
Let's reframe the whole provision.
My lord.
It says, now let's read it like this.
My lord.
The Supreme Court may make rules regulating the practice and procedure of the court.
Yes, my lord.
So are you saying that Supreme Court had to be advised about the Constitution, had to be advised about the law, because it would make rules which will be completely in violation of the Constitution and the law? So it would have been much simpler drafting to start it with the Supreme Court. Rules regulating practice and procedure of the court. Your contention is that a high body, as the constitutional body, as the Supreme Court, had to be reminded that there is a constitution in existence. Don't violate it. That's a very strange proposition.
No.
You are putting redundancy to the words subject to the constitution and law, because what you are saying can equally be said by using these words.
My lord, with the utmost respect, my lord.
If you read it
let's hear the council.
Yes.
Please सुन लेते हैं council को.
I'm also reading it the same way. The Supreme Court may make rules and regulating the practice and procedure of the court,
My lord.
subject to the Constitution and the law.
My lord,
Which means Supreme Court can make rules,
Yes.
whatever rule it wants to make. But it can't go beyond
the Constitution or any law which already exists.
So there
तो
is
वो मेरा सवाल अपनी जगह ठहरा. हजूर आप जवाब तो दे दीजिए.
My lord, with the utmost respect, I'm not reading it
utmost respect को छोड़िए, सिर्फ जवाब दे दीजिए.
अच्छा सर, आपके साथ
मेरा वक्त की कमी है.
जी, I know, my lord. I'm just saying that subject to law, subject means some kind of
मैं आपसे
restriction.
कुछ और मैंने आपसे फिर से आप देखें जो मैंने सवाल है उसका तो आप जवाब नहीं.
मैं आ तो जाऊं उसमें.
नहीं, आप आएंगे तो अगर दिन निकल जाए. मैंने कहा अगर ये हम लफ्ज काट दें सब्जेक्ट टू द कॉन्स्टिट्यूशन एंड द लॉ, फर्क क्या पड़ेगा फिर?
जी,
ये इसका सवाल का जवाब दे दीजिए.
फर्क नहीं पड़ेगा, लेकिन पॉइंट इज दैट
नहीं पड़ेगा ना.
नहीं, लेकिन
थैंक यू.
इशू ये.
चलिए नेक्स्ट पॉइंट.
नहीं सर, पहले अभी सुन तो लें, मैं कंप्लीट तो कर लूं सर आपकी इजाजत से. अगर फिर भी कोई लॉ आप रूल नहीं बना सकेंगे which violates any provision of the Constitution.
Is this something to be taught to the Supreme Court?
No sir, but I'm humbly submitting subject to law does not mean the Parliament can legislate. Humble submission. Subject to, क्योंकि जहाँ Parliament, जहाँ Constitution power देता है Parliament को बना दिया, specific words are used.
चलें खैर, अब पता नहीं आप redundancy
I'm not assuming it is. I'm
1,
just
2,
saying.
3, 4, 5, 6 words of the Constitution we can delete as rendered meaningless.
Sir,
I'm reading it like that if I accept your
Sir,
contention.
subject to only means, my humble submission is that subject to only means that there's some kind of a restricting, because the constitutional power, which is a continuing power, is being given to the Supreme Court.
Noted, next point.
The point is that the words used in the if Parliament, if Constitution is giving power to the to make any law, it specifically used certain words in the Constitution. If my Lord kindly sees 154(5), Article 154(5). Next page. My Lord, until Majlis Shura Parliament makes provision by law in this behalf, the Council may make its rules of procedure. These are the words. Then Article 6.3, my Lord, if my Lord kindly sees Article 6.3. Article
6.3 or 63?
6.3. Article 6, subclause 3. I see him. Yeah. 6. Article 6. Majlis shall by law. Article 6, my Lord. Yeah.
जी पढ़ लिया
जी Majlis shall by law provide punishment of persons found guilty of high treason. Then my Lord will kindly see 151(2), freedom of trade. And my Lord also reads 150, subject to clause 2, trade, commerce, intercourse throughout Pakistan shall be. Majlis Shura may by law impose such restrictions. May by law. Again, sir. Then my Lord,
what is the point you're making?
I'm making.
You're just citing the provisions.
My Lord, if the word in the 191 was the Parliament can make law, these kind of expressions as provided in the Constitution would have been used, my Lord. My humble submission is that when the Constitution is giving the legislature a power to enact a law, then specifically words are used in the power.
Mr. Zubairi, there's another question.
My Lord.
Once the rule-making power has been exercised
My Lord.
by the Supreme Court in terms of the Constitution, because the power vests in the Supreme Court, can subsequent legislation displace, as this Act purports to do so, can subsequent legislation displace the rules that have lawfully been and constitutionally been framed by the Supreme Court?
That's my humble submission. They cannot, for the simple reason, because then it will become ad nauseum. For example, can now the Supreme Court, which can make law regulating its practice procedure, make a law overriding the Parliament's making of the law? Then the Parliament will do it. Then where will we stop? So my humble submission is that could not have been the intention of the framers of the Constitution, that to give power to Parliament, because they are separation of power. Once the Honorable Supreme Court has made the rules regarding regulating the practice procedure, the Parliament does not. But that practice and procedure, the rules, cannot be in violation of any constitutional provision, any law which existed, sir.
The core question is, where does the Constitution confer, in which institution confer the power to make rules?
Ji.
Whether it is the Parliament or is it the Supreme Court?
Ji.
If it is the Supreme Court, the only restriction is that the Supreme Court can do so within the framework of the Constitution and the existing law.
My Lord.
And that's it.
Yes,
the Parliament cannot, because the power does not vest in the Constitution in the Parliament in terms of Article 199.
191, my Lord.
Mr. 191.
Next point.
My submission on this score is that's the reason I was saying.
I would really want to hear you, Mr. Zubairi.
Sir, my Lord is asking a question.
नहीं वो आप बात तो करें फिर सवाल उठेगा यकीनन.
पूछ रहे हैं, इसी बात से सवाल उठा है सर. जी.
Now, if I may ask you, these words subject to the Constitution, if these words were not there at all, and the Supreme Court were to make rules, and someone were to point out, well, sir, this proposed rule X is contrary to the Constitution, the answer would presumably be, the Supreme Court would say, well, okay, yes, you're right, so we can't make rule X, right? So in that sense, saying subject to the Constitution is always redundant.
Yes.
Because it's always going to be there.
There.
Seems to me, but this is the question, that perhaps there is more subtle. The Constitution, of course, can also be amended. Yes?
Yes,
Under
madam.
Article. But by and large, the Constitution is regarded at any given time to be fixed. Right? This is it. Underneath it, whatever happens by the judiciary, by the executive, by the legislature. So maybe the point in saying subject to the Constitution is not to make the obvious point that everything is always subject to the Constitution. Everyone knows that. Rather to fix the position of law, that when the rules are being made, what you just said,
Yeah, Lord.
when the rules are being made by saying subject to the Constitution and the law can only be as at that time.
At that time, sir, when the rules are
Maybe
framed.
this is the point that is being made here, because
Yes.
otherwise I was thinking about this, and I've been thinking about this since the case started. Why subject to the Constitution? Because everything is always subject to the Constitution.
Ji.
Mr. Zubairi, I just want to say one thing. The day we hear this case, the weeks we hear this case, our institution exceeds our disposal. The day we don't, our disposal exceeds our execution. If you think this is a never-ending hearing, this is the last day of the hearing.
My lord.
Please remember that. You can argue till 11:30, and each one of us may have their views. Let them be expressed in judgments. I want to hear counsel.
Sir, when a
I mean, if
question-
you,
My lord,
please continue. We will restrain ourselves. You just continue your argument so we can be enlightened what you want to tell us, and we can record it, and we can either agree with you or disagree with you in our judgments.
Sir, my lord,
Please, next point. Please go on to the next. Please go on to the next point.
So my point is that, again, my lord, that when the law is being given to the parliament, the
आप repeat ना करो ना, point
so hence subject to law, and for that I want to take you, my lord, I have placed certain case law before lordship, if my lord has that.
दीजिए,
जी।
दे दिए या देंगे?
ये रखे हुए हैं सर,
पहले से नहीं दिए?
सर दिए हैं, बहुत पहले से दिए हुए रखे हुए हैं।
आज?
नहीं सर, मतलब उन्होंने कहा जब आप आर्ग्यू करेंगे उस वक्त दीजिएगा, मैं तो कब हर रोज लेके आ रहा हूँ सर।
Sorry, this is most unfair. हमने कहा था लोगों को फाइल कर दें।
तो ये केस हम
हाँ, but ठीक है, you are right, we are wrong.
नहीं सर,
we have told everybody to file. हाँ, भी कागज के टुकड़े आ रहे हैं बीच में से, और ये कोई आसान चीज है पढ़ना?
इस लॉ है सर, इसमें
तो पहले नहीं कर सकते थे फाइल?
जी।
इन दुनिया में ऐसे होता है या सिर्फ निजाम अदल में ऐसा चलेगा? आगे दुनिया की हम तारीख में बताते हैं। ये जरा प्लीज ठहर जाइए ना कि अमेरिका में क्या होता है, विलायत में होता है। आप ये करें अमेरिका विलायत में जा करके, फिर क्या होगा आपके साथ? वहां तो आप सारे वेस्टर्न ट्रेडिशंस बताते हैं, इस्लामिक ट्रेडिशंस तो बताते नहीं है। अगर कागज के मामले में ठीक है भाई, मेरी मर्जी जब मैं करूं। भाई सच अ सीनियर काउंसिल।
My lord, may I take page 144 of this? Is a case.
आप हमें प्रोपोजिशन बताएं, पहले
Proposition
प्रोपोजिशन
is
बताया
subject to
जाता
law.
है।
How a subject to law has to be interpreted. That is my.
ठीक है, बता दें केस का नंबर।
Page, its case is page 144 of this booklet, sir.
जी।
Winberry versus Salisbury. It's a case from the American jurisdiction, and they have interpreted this word. What is the meaning of? And their constitution also provided this thing.
And their constitution also permits of documents in courts. चलिए खैर, 144.
Sir, this is just a
ये
case law which
सुप्रीम
I'm
कोर्ट का है,
citing.
ये सुप्रीम कोर्ट का
नहीं
जजमेंट?
sir, it is Supreme Court of New Jersey, sir.
अच्छा ठीक है।
जी। My lord, page 145, if my lord kindly sees the sixth line from the top.
देखिए वो जरा मुनासिब नहीं लगता है। सुप्रीम कोर्ट ऑफ पाकिस्तान फुल बेंच में, सुप्रीम कोर्ट ऑफ न्यू जर्सी का जरा ठहर तो जाइए ना। हमें हमारा लेवल इतना नो तो ना कर दें। सुप्रीम कोर्ट ऑफ अमेरिका तो बताए, सुप्रीम कोर्ट ऑफ न्यू जर्सी को हम फॉलो करेंगे।
सर मैं सिर्फ बता रहा हूँ कि
हाँ
उन्होंने
बता
इस-
दें, जबानी
उनके-
बता दें, हम आपकी बात में ज्यादा वजन है बल्कि
सर,
सुप्रीम कोर्ट ऑफ न्यू जर्सी में।
उनके कॉन्स्टिट्यूशन में इस तरह का लफ्ज नहीं है, लेकिन उनके जो स्टेट्स हैं उनके कॉन्स्टिट्यूशन में इस तरह के लफ्ज हैं। काइंडली सी द सुप्रीम कोर्ट शैल मेक रूल्स गवर्निंग द एडमिनिस्ट्रेशन ऑल कोर्ट्स स्टेट एंड सब्जेक्ट टू लॉ द प्रैक्टिस एंड प्रोसीजर ऑफ ऑल सच कोर्ट्स। दिस इज द लॉ व्हिच दे इंटरप्रेटेड एंड माय लॉर्ड इट सेज पैरा 2 ऑन पेज 145
The phrase subject to law.
The phrase subject to law is not only ambiguous but elliptical. No
What
word
is what is elliptical mean?
Sir, मतलब कि it is confusing.
बताइए।
जी.
You're reading a word.
जी.
You tell us the meaning of the word.
Continuous, sir. Continuous. No word in the law has more varied meaning than the term law itself. Nor is the phrase subject to crystal clear, for the phrase implies a limitation rather than a grant of power. It is argued by plaintiffs subject to statute or legislation.
It is argued. भी judgment भी नहीं है.
जी आ रहा हूँ sir. If subject to, अब नीचे last paragraph sir. If the subject were to interpret it to mean subject to legislation, it would necessarily follow that once the legislature has passed a statute in conflict with the rule of court, the rule-making power of Supreme Court will become functus officio. For it would intolerable to hold, as has been suggested to us, that after the legislature has passed an act modifying a rule of court, the Supreme Court might in turn adopt a new role overriding the statute, and so on ad nauseum. And yet, if subject to law means subject to legislation, any other construction of rule-making power would be in conflict with fundamental rule of constitutional constraint that unless the context clearly requires otherwise, a constitutional grant of authority is to be interpreted as a continuing power. My lord, then the last three lines, page 146. All these
पेज 147 से पढ़ लीजिए।
जी हाँ, उसमें आ रहा हूँ।
पेज 147 लास्ट 2 लाइन से पढ़
जी
लीजिए।
बहुत बेहतर सर।
वो वही आ रहा है, नीचे आ रहा है।
जी इसमें फिर सर पेज 146 पे
147 की लास्ट 2 लाइन से पढ़ लीजिए ना, वो आपको थोड़ा सा उसमें जवाब मिल रहा है।
जवाब आ रहा है कि मैं कुछ आपको पॉइंट आउट करना चाह रहा हूँ कि पेज 146 से लास्ट 3 लाइंस देख लीजिए। मैं सिर्फ जो पॉइंट्स हैं उसको आपको दिखा दूंगा सर। It is conceivable that the people granted continuing power to the courts in all these respects or withheld it with reference to rule making, sir. Then, my lord, page 147.
लास्ट 2 लाइन।
If the regime may amend the rules or it may decide the extent to which the law, division, and charge shall exercise the powers functions of other division. It may control the degree to which legal and equitable relief may be granted in any cause. We think it may be safely and that no such thoughts are ever in the mind of the member of Constitutional Convention or any citizen who voted for the Constitution. Yet, if subject to law means subject to legislation, such results might inevitably follow. The courts, in some of their essential judicial operations, instead of being one of 3 coordinate branches of state government, would have been rendered subservient to the legislature in a fashion never contemplated by any. What then is the meaning of subject to law? The only interpretation of subject law that will not defeat the objective of the people to establish an integrated judicial system which is independent and which will at the same time give rational significance to phrase is to construe it as equivalent of substantive law as distinguished from pleading and practice. The distinction between substantive, which defines our rights and duties, and the law of pleading and practice, or through which such rights and duties are enforced in courts, is a fundamental one that is part of daily thinking of judges. Substantive law includes much more than legislation. It comprehends also the rights and duties which have come down to us through the common law. The phrase subject to law in Article 6 of the Constitution thus serves as a continuous reminder that rule-making power as to practice must not invade the field of substantive law as such. While the courts necessarily make new substantive law through the decision of specific case in common, they are not to make substantive law wholesale through the exercise of rule-making power. That is the concept. So subject to law does not give power to legislate. It is not subject to legislation. Where it is made subject to legislation, then the Constitution uses the words. Make such as pointed out. ये कई articles हैं of the Constitution, मैंने 154, 150, then 140,
Don't repeat.
240, 241 and 242 के अंदर भी यही लफ्ज हुआ है make by
Mr.
law.
Abid, the law which is in dispute has been made pursuant to Article 175(2).
Yes, I'm coming,
This
sir.
is the power of
Sir,
judicator.
but utmost
So,
respect.
in the law itself, pursuant to Article 175(2),
Read
read with Article
Article 191.
191.
Article
We
191.
are making much time on 191. What about Article
I'm coming to that.
175(2)? Because
I'm
no
grateful to
court has jurisdiction unless conferred by the Constitution or the law.
Yes, but 175(2) cannot be read in isolation. That is
No,
the
no,
judgment of
it
this
is,
court.
it is the dedicated to the judicator.
Sir, may I please
So
submit?
power of the court are covered under Article 175.
Read with Article
Read
142.
with, that is the law that have made under pursuant to 191, read with 191.
Yes,
but
but
the
the-
law has been made pursuant to Article 175.
My lord,
उसको पढ़े ना 2 में आपके वो
जी, हाँ।
jurisdiction,
जी।
किसी कोर्ट का jurisdiction जो है that is related and
तो
based
इसका
on
मतलब
the
फिर
premise of
जी, बिल्कुल आप
Article
सही कह रहे हैं।
175(2).
My lord, then provincial law भी आपके लिए
कोई नहीं
province
है.
बना
The
सकता है.
courts 175. There
Two.
shall be a Supreme Court of Pakistan, a High
जी.
Court for each province.
And such a
And
court
High
has may be
Court for
established by
Islam.
law. In no court, number
Article 2,
G,
no
court shall have any
jurisdiction
jurisdiction save as is or may be conferred on it by constitution by or under any law. That is synonymous. But humble submission is that this honorable court has interpreted when it deals with the Supreme Court, it has to be read with two further articles, Article 142A and Entry 55. May I take your lordship to Article 142A?
Yes.
And that is a judgment of this honorable court, sir.
So this article, I don't understand.
It's not a standalone article, sir.
It is?
Does, no, with humble submission, that is.
No, you are now reading words into the Constitution.
I'm reading-
No, where does it say it's not a standalone article?
It's because the judgment of the
So you
Supreme
can
Court says
imply
so.
it, but it doesn't say so.
Sir, I'm not saying anything on my own. I based my arguments on case law and I cite a case law on that of this honorable what they have said.
I think the whole object of a full court hearing counsel is being missed. If all we are going to do is keep referring to case law, we are sitting, the full court is sitting. I don't even think you understand the gravity of it. To understand, to learn from counsel.
Yeah.
Refer to this judgment, refer to that judgment. Bhai, the plain words of the Constitution, you don't want to read. Then you want to read New Jersey Supreme Court. Let's read plain words of the Constitution.
But
Let's hear counsel formulate submissions on that.
My humble-
Then by all means, if there is some ambiguity, we can
My
go
humble
to
submission-
precedent.
My humble submission
You see,
is that
the main rule for constitutional interpretation is that the entire constitution has to be
Read as a whole.
in a context. You cannot pick up one article and just read it in isolation because there are other articles which either may restrict or enhance that power
Yes.
which exists in
and
one
how that power is to be
particular
exercised. Now, what is the law they are talking about in Article 7175(2)? No court conferred on it by constitution or by under any law. So the only two articles of the constitution when it concerns the honorable Supreme Court is Article.
ये बार आप ऑनरेबल सुप्रीम कोर्ट नहीं होता है, सुप्रीम कोर्ट ऑनरेबल
Supreme-
जजेस होते हैं.
जी, सर,
अंग्रेजी का तो सही इस्तेमाल कर लेना.
Sir, हम
ऑनरेबल
ये-
पार्लियामेंट
हम-
नहीं
हम
कहते
ये
हैं.
भी आप भी करते हैं. हम यही करते हुए आ रहे हैं, सर.
चलिए आगे चले, पॉइंट
जी,
बताएं ना आगे.
my humble submission is that
Mr. Zubairi-
Article 175(2)
जी ठीक है,
has to
हमने
be
पॉइंट
read
नोट,
with
आपने कहा हैज टू बी रेड विद
Article 142A and Entry 55.
142A and entry 55.
55.
Let's read 142A.
Mr. Zubairi, the point, it seems to me over here is the question that when we are talking Article 191, we are talking of practice and procedure.
Procedure, ji.
Are we really talking of the jurisdiction of the court?
No.
We are talking of a direct grant by the Constitution
Of the regulation.
of rule-making power with regard to practice and procedure.
Yes.
So, when in this act, in the preamble, when reference is made to Article 175(2), which relates to jurisdiction,
Well on.
is
Then you
anything
go
that
to
could be-
142A.
What is, would that be correct, or would that perhaps be not entirely correct? Because here we are not talking of the jurisdiction of the court, but of its practice and procedure.
बिल्कुल सर.
Would-
अमित साहब,
Jurisdiction
इस कानून ने एक और काम भी तो किया है. इस कानून ने एक अपील का हक भी तो
जी,
दिया है, तो वो
जी,
प्रोसीजर में तो नहीं आ सकता है ना.
जी.
तो वो सिर्फ 175 मेरे जहनियत के मुताबिक वो सिर्फ 175(2) ही में आ सकता है. उसको प्रोसीजर मैटर हम नहीं समझेंगे.
वो भी तो एक जुरिडिक्शनल पॉइंट है, वो 142A और एंट्री 55 के तहत आपको पढ़ना होगा.
बता दें हमें.
जी, 142A देखें सर. Because they are not the word
आप पढ़ लेते हैं ना, please,
175.
पढ़ लीजिए,
जी.
please.
175 talks about jurisdiction. 142A sir.
नहीं, आप शुरू से पढ़िए 142. यहाँ भी सब्जेक्ट टू द कॉन्स्टिट्यूशन लिखा
जी,
हुआ है.
मैं आ रहा हूँ सर. सब्जेक्ट टू कॉन्स्टिट्यूशन. मजलिस शूरा shall have
नहीं, ऊपर सब्जेक्ट टू द कॉन्स्टिट्यूशन.
जी,
अब इसका
subject.
बताएं इसका क्या मतलब है.
The constitution is subject to it. It cannot be any law cannot be in violation of any constitutional provision, existing provisions of the constitution, sir. Majlis-e-Shura Parliament shall have exclusive power to make laws with respect to any matter in the federal legislative list. So this power to make law, exclusive power to make laws as provided in federal legislative list, sir. And now entry 55.
आप हम यहाँ पे इंटेंशन ऑफ द लॉ मेकर और कॉन्स्टिट्यूशन मेकर देख रहे हैं. आप कहते हैं कि रूल्स बनाने का इख्तियार दिया गया है और सिर्फ लॉ के तहत नहीं होगा जो ऑलरेडी एग्जिस्टिंग लॉ होगी. अगर आप इंटेंशन ऑफ पार्लियामेंट देखना चाहते हैं तो आप आर्टिकल 175A सब आर्टिकल 5 देख लें
जी
सब 4
जी
यहाँ पे सब्जेक्ट टू कॉन्स्टिट्यूशन और लॉ नहीं है।
जी सर।
द कमीशन में मेक रूल्स रेगुलेटिंग इट्स प्रोसीजर।
जी
अगर इंटेंशन कॉन्स्टिट्यूशन मेकर का ये है कि वहाँ तो सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ होना चाहिए, तो यहाँ क्यों नहीं दिया गया सब्जेक्ट टू कॉन्स्टिट्यूशन?
because humble submission is
पढ़
that
पढ़ लें
जी I'm reading it.
175A
The commission may make rules regulating its procedure. Sir,
यहाँ तो सब्जेक्ट कॉन्स्टिट्यूशन नहीं है
सर आपने तो
इससे इंटेंशन आप क्या करेंगे?
फुल कोर्ट ने तो सुप्रीम जुडिशियल काउंसिल की रूल मेकिंग पावर रूल की कोई प्रोविजन नहीं, उस पे भी कहा है दे कैन मेक रूल्स, द सुप्रीम जुडिशियल काउंसिल कैन मेक रूल्स व्हिच विल हैव कॉन्स्टिट्यूशनल स्टेटस। ये है जजमेंट ऑफ द ऑनरेबल।
मेरा सवाल शायद मैं नहीं समझा पा
जी मैं आप समझ गए, आप कह रहे हैं इसको क्यों नहीं इस्तेमाल
इंटेंशन देखना है
जी।
यहाँ पे तो ये कहा है विदाउट मेंशनिंग द वर्ड सब्जेक्ट टू कॉन्स्टिट्यूशन लॉ।
जी
यहाँ सिंपल कहा है द कमीशन में मेक रूल्स।
जी
बस तो बात समझ आती है कि आपने रूल लॉ को नहीं देखना जो एग्जिस्टिंग है या पहले से है
जी।
वहां पे ये दिया गया है कि सब्जेक्ट टू कॉन्स्टिट्यूशन, ये तो अंडरस्टूड है, सब्जेक्ट टू का मतलब है उसके ताबे होने चाहिए
जी।
अमूमन होता भी ये है कि पहले
रिस्ट्रिक्टिव वर्ड है, नॉट एनेबलिंग
पहले
प्रोविजन।
एक्ट बनता है उसके बाद रूल बनते हैं
जी।
रूल कभी एक्ट से ऊपर नहीं होते हैं, ना एक्ट से हट कर होते हैं। कोई भी रूल अगर बनाया जाए वो एक्ट के डोमेन से या कॉन्स्टिट्यूशन के डोमेन से बाहर होंगे तो स्ट्राइक डाउन होंगे। तो यहाँ तो ये जरा बता दे कि इंटेंशन वाज़ेह नहीं है दोनों आर्टिकल्स में।
सर इसमें मेरा humble submission will be that in this case sir still no rule can be made in violation of the constitutional provision।
अब आप जी सवाल का जवाब या तो सवाल नहीं समझे, मैं आपके लिए आसान तरीके से बता देता हूँ। माय लॉर्ड पूछ रहे हैं आपसे कि जहाँ तक जुडिशियल कमीशन ऑफ पाकिस्तान का वहाँ ना सब्जेक्ट टू लॉ है ना सब्जेक्ट टू कॉन्स्टिट्यूशन है, इसका मतलब एक मतलब तो ये निकलता है कि ना कोई लॉ बन ही नहीं सकता है उसके मुतालिक, वो हमेशा कमीशन खुद ही बनाएगा अपने रूल्स। ये सिंपल रीडिंग है जी। और वहाँ 191 में सब्जेक्ट टू लॉ एंड कॉन्स्टिट्यूशन इसलिए लिख दिया गया कि आइन में भी हो सकता है और लॉ में भी हो सकता है। तो ये उन जमाल साहब की अंडरस्टैंडिंग गलत है तो जरा समझा दीजिए।
बिल्कुल सही, मैं जो अर्ज कर रहा हूँ कि जहाँ सब्जेक्ट टू यूज होता है वर्ड वहाँ ऑलरेडी का कोई रूल इसके वायलेशन में नहीं बन सकता, which is already existing subject to constitution, subject to law, already substantive law exist करता है, उसमें आपकी रेगुलेशन और प्रैक्टिस एंड प्रोसीजर पे आप नो
आप
फिर इसमें अगर नहीं यूज किया गया तो इसका मतलब ये इसको सब्जेक्ट ताबे नहीं किया जा रहा है।
ठीक है, ये आपका इंटरप्रिटेशन
जी, इसको ताबे नहीं किया जा रहा है, but still no rule can be made in violation of the constitutional provision or any law।
ठीक
जी
Mr. Zubairi, is
Malo.
it so that it is the only Supreme Court which can make rules under Article 199? High Court and Federal Shariat Court, they are having the same powers?
Sir, 202 of the constitution gives the power to make rules to the high court, sir।
And is there any law made for those two courts?
उनके अपना प्रोसीजरल लॉज हैं हाई कोर्ट में, एंड दैट जजमेंट ऑफ सिंगल बेंच जजमेंट वाज साइटेड बाय मिस्टर भंडारी ऑन द लास्ट डेट 2021 लाहौर, व्हिच डील्स के व्हाट इज द मीनिंग दैट rules can be made but they are no, they have to be read with the anti 55 does not apply to them, because that's why the rules jab law reforms ordinance की बात की थी।
Parliament has put up clog on the Supreme Court, why not on High Court and the Federal Shariat Court?
The High Court में है
What were those
202
special
sir।
reasons to constitute this act?
Sir, 202 kindly be seen, subject to constitution and law, a High Court may make rules regulating the practice and procedure or of any court subordinate to it। तो 202 is
203J is the
जी
Federal Shariat Court।
जी 203
नहीं, आप माय लॉर्ड का सवाल नहीं समझे। आपका पहले वाले सवाल का जवाब ये था क्योंकि रूल्स बन गए हैं तो अब सब्जेक्ट टू कॉन्स्टिट्यूशन एंड लॉ has been rendered effectively meaningless। माय लॉर्ड का सवाल ये है, अगर आपकी ये बात सही है तो सुप्रीम हाई कोर्ट के कौन से रूल्स और फेडरल शरीयत कोर्ट के कौन से रूल्स बन गए थे, ये फिर इसका जवाब क्या होगा? ये मैं इसका जवाब आपने नहीं दिया।
सर पहले मैं आपकी बात का वो जवाब दे दूं।
नहीं, मैंने सवाल नहीं पूछा, मैं सिर्फ आपको माय लॉर्ड का सवाल बता रहा हूं।
आपने कहा कि अब नहीं, मैं अभी भी कहता हूं आज आप रूल्स बनाने जाएं, they cannot be in violation of the constitution, subject they have to be subject to any substantive law।
I can only use one word for it, profound।
जी, but still आपने ये कहा कि मैं कह रहा हूं कि जी अब नहीं हो सकता। My lord, rule making power is a continuous power।
मगर माय लॉर्ड का जवाब नहीं दिया आपने
जी मैं दे रहा हूँ उस पे सर. इसके अंदर भी जो लॉ उन्होंने बनाया है, that has to be subject to constitution and the law, and that is the interpretation given in the judgment of.
इसके लिए तो कोई
And you see,
legislation नहीं हुई ना।
the Lahore High Court in a full bench judgment, जब ये क्वेश्चन अराइज हुआ था कि गवर्नमेंट ने भी लेजिस्लेशन कर दी थी और हाई कोर्ट ने रूल्स भी बना दिए थे, द हाई कोर्ट सेड यू कैन नॉट डू दैट.
Do that. जी.
Once the power vests in the High Court, the government or the legislature cannot legislate in matters relating to rules because the rule-making power exclusively vests in the High Court.
जी. So this is अगर judgment जिस पे आई PLD 2021 Lahore page 544 and relevant portion is para 61 page 580 onwards sir.
पढ़िए
जी.
पढ़िए.
PLD दोबारा साइटेशन बताइए.
PLD 2021 Lahore page 544. Follow para 61
आपकी बुक में कौन सा हिस्सा है?
page 580 page
की
561.
बुकलेट में कौन सा है?
जी. बुकलेट में नहीं है सर. मेरे नोट्स भी हैं, मैंने अपनी CMA भी दाखिल की हुई है, पर क्योंकि माय लॉर्ड ने पूछा तो इसलिए मैं निकाल के पैरा 61 और बात 202 पहले कोट करते हैं और फिर मैं आई रीड दिस पैराग्राफ सर.
ये पेज 544 आप कह रहे हैं?
580 सर.
ये तो
It starts at page 544 and relevant portion which my lord's observation is at page 580.
सिंगल बेंच का जजमेंट है.
जी.
Why you are citing it before full bench?
तो इसमें इंटरप्रेट हुआ है हाई कोर्ट की पावर्स के ऊपर जो 202 की पावर्स हैं. जी.
सिंगल बेंच का जजमेंट फुल कोर्ट को साइड फर्क पड़ता है क्यों नहीं पड़ता?
इसमें एक लॉ बना दिया था, अमेंडमेंट लॉ, और रूल्स में अमेंडमेंट कर दी थी. दैट वाज चैलेंज एंड दैट वाज सेट असाइड. काइंडली मे आई रीड योर लॉर्डशिप काइंड परमिशन.
You want to?
G. Thus, the High Court have been conferred the constitutional power regarding rules and procedure, which may not only regulate the practice and procedure of a High Court, but also any court subject to it. In exercise of this power, HC has made rules entitled High Court Rules and Orders, which contains elaborate procedure to be followed by the court subordinate to it in matters relating to adjudication of cases before civil court. Thus, not only has the High Court been delegated the power of making and amending rules in the first schedule by the court itself, but also by the Constitution by virtue of Article 202. The central question regarding power of High Court has escaped the attention of Government of Punjab while promulgating the amendment ordinance, which impinges upon the powers of Lahore High Court to enact and amend the rules. This proposition being stated for a simple reason that the amendments issued by amendment ordinance are made part of the substantive body of the court, not in the rules comprised of first schedule, and also, almost all of them relate to details of procedure to be followed by civil courts in adjudication of cases, which as numbered has traditionally been part of first schedule. A grossly egregious and anomalous situation has now been created with pits and procedure introduced by amendment against the amendments made by Lahore High Court, which now run a parallel course. There are serious contradictions between the two processes, which is most cases are irreconciled. Although, I'm reading from the last line, although in such matters considered as is not normally assigned of, but in peculiar circumstances where across the board amendments in the rules have been made by committee of the High Court only a few months, Government of Punjab is obligated to have consulted LC for purpose of reconciliation. Also, while a reference to Article 2 of the Constitution has already been made, it also by implication follows that exercise of rule-making powers is constitutional, which resides in the High Court. Therefore, if such power has already been exercised, emerges as an unwritten rule to be followed in all such matters that is of utmost important concern to be held and the government of province. It is not only essential but also to preserve the independence, so that is unique situation where judicial legislation is permissible. So this is the thing, once the constitutional power has been exercised by the court, because these rules made by this court have constitutional backing, this is what the judgments have said, it has constitutional backing. Even the rules under the Supreme Judicial Council, PLD 2021 Supreme Court page 1, page 94 says that though Supreme Judicial Council does not, the law does not allows them to make rules, but they made the rules, Supreme Judicial Council, and those rules have constitutional status.
This is a very look at Article 203E in
Yes.
relation to the Federal Shariat Court.
Ji.
Take a look at Clause 2. 203 capital E, Clause 2.
My lord. Yes, my lord. The court shall have power to conduct its proceeding and regulates its procedure in all respect as it deems fit.
This doesn't seem to be regulated by law.
No, it doesn't, sir.
So therefore, does this mean that the rule-making power of the Federal Shariat Court is on a higher pedestal as compared to the Supreme Court or the High Court?
No, my humble submission, both are constitutional powers, sir.
So-
both the Supreme Court, the High Court have been granted.
I'm just coming off from what my learned colleague was asking you about the rule-making power of Federal Shariat Court. If read literally, this would mean that the Federal Shariat Court is put on a pedestal much higher than even the Supreme Court, to which appeals lie from the Federal Shariat Court.
So then there are judgments of this honorable court that if there's a conflict between a substantive provision and provision of the Federal Shariat Court, then those substantive provisions will prevail, sir. So that is also a judgment of this honorable court on this field. That constitutional provision will be higher pedestal than the provisions under the Federal Shariat Court chapter, sir.
Thank you.
Jai, my lord. So my submission is that I was coming to that, that the jurisdiction aspect, sir. Jurisdiction aspect is that, yes, Article 175 gives the Parliament the jurisdiction to make law, but law has to be read with Article 142A, which I read to your lordship, sir, and entry 55, sir.
191 confer jurisdiction or does it confer power?
I'd say it confers power, sir, because it says regulated. The most important word is that the rule make it regulate the procedure, practice and procedure. What is the meaning of regulate?
91 is not a jurisdiction conferring article.
It is conferring power.
Conferring article. And there is a distinction between jurisdiction and power.
And that has been very elaborately dealt with by this honorable court in Ziaur Rahman's case, sir. PLD 1973 Supreme Court, page 49, and the relevant question is, okay, what is the difference between judicial power and jurisdiction, sir?
PLD 73?
3 Supreme Court, page 49, sir. And I'll give you lordship the citation. तुमने बनाया हुआ तो है?